potential 5 minutes in there too. So good evening and welcome everyone. My name is Kit Needham. I'm the Assistant Dean for Entrepreneurship Initiatives at CMU and Director of Project Olympus, where we help student, faculty, staff, alumni explore the commercial potential of their innovations and their research. And this series has been going on for a number of years. And done in collaboration with Stephanie. Do you want to introduce yourself?
Yep, I'm Stephanie Dango. I'm a professor of practice at University of Pittsburgh Law School. And I teach everything from transactional drafting of organizational documents, entertainment law, commercializing new technologies, wicked problems, innovation. Anything sort of innovation related sort of comes across my desk at Pitt. So I'm happy to be doing this. And many years ago, I worked with David and Mike at K&L Gates. So it's fun to be back.
So Rhonda.
Thank you. I am Rhonda Schultz. I'm the director of the Big Idea Center, University of Pittsburgh's Hub for Student Innovation and Entrepreneurship. So we work with students from freshmen to postdoc, even surgical residents at UPMC who are exploring their innovative and entrepreneurial ideas and help them take those from an idea to reality.
Very good. I'm just going to give an honorary shout out to Don Morrison, who I think is he still one of your EIRs? Yes. So he's everywhere. He's everywhere. But now he's the CEO of a company. So he's got another gig. All right. So now I'd like to turn it over to our presenters, David Lehman from K&L Gates and Mike Pavlick, who is, I think, with their employment practice. And David, I'll just let you take it from
here. You're not doing your intro.
Oh, gosh, thank you. So it's COVID brain in there. So these are part of what we call the Connect series, and the purpose is to give others an opportunity to do a shout out if you're looking for a team member, if you're looking to join a team, if you have an announcement, or if you need help with something. You could just briefly give your name and say what it is you would like. And so you can actually just introduce yourself and what you're doing too, just in case somebody has something to say about it. So this is just unmute and shout.
Or not.
Okay, well, if you think of something along the way or when we get to the end, then we'll give you another chance at doing that. So you can also put something in chat if you don't have anything, you don't want to talk. Okay.
All right. So then we'll take it. So welcome everybody. My name is David Lehman. I'm a partner with K&L Gates, practicing in the corporate and emerging growth kind of area, together with anything anybody else will pay me for. Let me let my partner Mike Pavlick introduce himself as well.
Hi, Mike Pavlick. I'm a partner in the Pittsburgh office, and I focus my practice on labor and employment law, and I've been doing this for way too long.
So let me, I'm going to share my screen if I can, if I do this right.
Okay, just takes practice, David.
There we go. How's that? Can you see it?
Yes, it's not in presentation mode, but you can hit the little button, but I can see it and it's the right view.
So
that's it.
Is it now in it? Cool.
Well, it hasn't happened yet. So
it hasn't happened because I hit the thing. I can see it in
I'm still seeing the sides on the side.
Let me see if I can maybe I'll do this different. Let me do this. Wait. What did I do wrong? Let's see. Because I hit the thing. So you can see, still see the side thing?
No, you know what? Go over. You didn't hit the right one. Come on over, down at the bottom. Keep going over. Not that one. No, right there.
That's what I hit.
Did you?
It's not going into it for you? Because it is for mine. So it must not be doing it in the...
you're just sharing that. Do you have two screens? Because you're probably sharing the wrong screen.
So when I go like this, so let me do this 1 second. I probably have myself totally confused. 1 second. Sorry for confusion, guys. 1 second.
It's all right. We understand.
Yeah, really. The good news is I don't do 1 second. No, let's try this. All right, so can you see are you seeing the header? Are you seeing the front one, appointment and employee matters?
I can see that, but it is one of those ones I have. There, sometimes in there you go to the top of the screen and you can have switch view.
Hmm. One second.
Or
Or
do
You can do
slideshow.
slideshow. Look at slideshow and your cursor is almost there. Go to the left a little bit. But see, if he's seeing it, the right thing, then
Okay.
it's a switch view.
Yeah, you just gotta switch this view on Zoom, probably.
I have no idea what that means. Sorry.
Just
You can-
unshare it, unshare Zoom and then reshare and reselect the one that's in presentation mode.
Got it. Okay, let's try this one second. Got it. All right, so I'm gonna stop and then we're gonna not mess around with this much longer. Okay, so I stopped sharing. Right.
Oh, yeah, then click share and then should show you like several different screens you can share. Select the one
Right.
that's in presentation mode.
But there's none next thing. Okay, got it. 1 second. 1 second.
Who's our coach here?
It's Justin.
He's one of our EIRs. Very technically
I
savvy.
think I would have introduced you to it. No.
Uh,
Robotics and automation and all things Zoom, right?
Yep.
Yeah,
Yeah.
All right, this isn't working.
this
So let's-
voice comes down, so.
I'm not doing it right, so I don't want to waste people's time. So let me
That's
just
okay.
do this.
It looked fine the other way.
Yeah,
It's
we can-
not a full
it just-
presentation mode.
yeah. I'll just,
1 second. All right, can you see?
yeah,
And you see it the way it was before?
yeah, that's what we're saying.
That's the way we're gonna live with it. Okay, cool. So anyway, so, and now you're seeing the agenda?
Correct.
I see the agenda, right?
Good, okay, so, sorry for that. You just heard the introduction, congratulations. Mike is going to talk a little bit about hiring employees and the classification of workers and their significance. So on the employment side, I'm going to talk about what it's like to hire an employee, what the terms of that employment is, the covenants you should get, whether it be non-competes, restricted covenants, and making sure you have intellectual property assignment and how important that is. So the arrangement between the company and the employee, and we'll talk a little bit about providing employees with equity and what kinds of forms that can have and how much equity to give employees. So that's what we'll cover these things. I want to especially emphasize the last bullet point, which is to say question and answers don't wait. There's not that many people on this call, and I'd much rather talk about what you're interested in than what Mike and I want to talk about. So if you have questions, put up your hand, put something in chat. Kit will interrupt us and we'll talk about what you'd like. With that, let me turn it over to Mike.
Thanks, Dave. So I had a thought before. We've been doing this for a while now, and we've been done it in person in the past, and we've been doing it by Zoom recently. And we've been doing it by Zoom since the O closed. So I wonder if that's a coincidence or whether that is a cause. I don't know for sure, but what I do know is that you have now founded a very successful business, or at least a business anyway, and you are looking at hiring your first employee as part and parcel of that business. And I want to sort of walk through some preliminary considerations in terms of hiring an employee. This isn't meant to be exhaustive, but it is meant to provoke some thoughts. First, background checks. A lot of employers do background checks. Do you want to do a background check? There are certainly pros to doing it. You can learn important information. By the way, I can't spell, so I apologize. That should be information. But there's a lot of important information you can learn by doing a background check. The cons are you could learn information that you really don't want to know, information that can form the basis of a lawsuit. So for example, you can find out an arrest record, which probably can't be used. You can find out information about a person's participation in a group associated with a certain religion. And then when you don't hire that person, this person says, hey, you didn't hire me because you knew I was part of this controversial religious group. So there's no right or wrong answer. But what I do recommend, or what I do suggest, is that when you do background checks, if you do background checks, limit it to what you think is important. If you don't think an arrest record is important, then don't seek it. All right. Another concept in terms of background checks is pre-offer or post-offer pre-hire. And pre-offer means exactly what it sounds. Before you make an offer, you do these background checks. Things like credit checks can usually be done pre-offer. Things like criminal background checks can usually be done pre-offer. But there are some background checks or some pre-employment testing, like drug tests, that need to be done post-offer. In other words, you extend an offer, you make the person take the test, and then the hire is contingent upon a successful navigation of that particular test. So just keep that in mind, that sometimes background checks, and I'm using that term very inclusively to include things like drug testing, has to be done post-offer, pre-hire.
So Mike, can I just interrupt or ask
Yeah.
David a question? Of the startups that you work with, David, how many of them actually are doing background checks?
It's interesting. I think very few of them. Very few of them.
Yep, there's a cost to doing it.
If any.
Yep, there's a cost to doing it. And that could be one of the cons, right? Is there's
Yep.
just, it's not worth it. And if it's not going to trouble you, then don't do it, right? If you're going to find out, if you're looking for information that's not going to make a decision, or it's not going to make a decision easier for you or less easier for you, then simply don't do the background check. Authorization to work in the US, unlike background checks, that is not discretionary. You have to make sure that your workers are authorized to work in the US, and you are allowed to ask them if they are authorized to work in the US. Do be careful though, because if you ask them about their immigration or citizenship status as opposed to their authorization to work in the US, you may run afoul of certain discrimination laws, which leads into the last bullet point, which is don't discriminate in terms of your hiring, right? If you're hiring an employee, that employee is protected in most instances by various discrimination laws, age, race, sex, gender orientation, disability, national origin, ethnicity, et cetera. So make sure that you don't discriminate. So if we go to the next slide, David.
Yep.
Another consideration is, do we want our employee to be at will? And let's start off with the basic presumption that at will means that an employee can be terminated for any reason or no reason at all. And the quid pro quo for that is the employee can leave at any reason and for no reason at all. All right. So employment at will means basically that employees are free to leave and you're free to terminate the employee. Pennsylvania is a very traditional at will state. There is a strong presumption in Pennsylvania that employees are at will. And generally speaking, that presumption can only be overcome in two instances. Number one, the employee has a specific employment contract for a term. I employ you for 2 years. I employ you for 3 years. There has to be a specific term spelled out in the contract. The other way that a presumption can be overcome, the at-will presumption can be overcome, is if the employment contract has a just cause provision in it, which says that the employee can only be dismissed for just cause. The classic example of that is the labor contract, the collective bargaining agreement. But obviously you can have an individual contract with an individual employee that says thou shalt not be terminated unless you engage in conduct which gives us just cause for termination. Typically speaking, that's the only way you're going to take the employment relationship out of the at-will realm in Pennsylvania, at least. Some states are a little bit less traditional in that regard, but Pennsylvania, again, is very forgiving to employers.
Okay. So Mike, could that
yeah.
just cause be stealing? It could be incompetence. It could. I mean,
So it's a really good question, Kit. So incompetence typically is not going to be just cause. Just cause typically is a higher standard. It's some sort of affirmative conduct. I like to use the willful misconduct sort of criteria that's used for unemployment compensation. You engage in some sort of willful action, which is in violation of of the employer's policies or practices. Being a bad employee is not just cause. Punching somebody in the face is just cause. All right. And so that's generally the distinction that you make. One of the things is that, and I'm going to, if you're going to have a just cause provision, you want to put it in a contract, right? And one of the things you can do is spell out what constitutes just cause. And you may be able to expand the definition of just cause to include some performance related elements. But if you leave it to the law is going to look and say, okay, bad performance, not meeting goals is not going to be just cause for termination. If you do have if you do have an employee, you want to consider whether you want to have a contract, right? That contract can be written or oral. That's both a suggestion, but it's also a warning. Sometimes what you say may end up being a contract. You may not realize it's a contract, but you end up making something a contract. There has to be an actual contract. The terms can be implied sometimes. Okay. In other words, the courts could look at it and say, okay, we're going to apply this term into the contract, but there has to be an actual contract. And so the question that you have to ask yourself is, do I want my employee to be at will, or do I want my employee to be an employee with a term, an employee with a just cause provision? Obviously, an at-will employee arrangement has a lot of flexibility, and that is oftentimes desirable, particularly for smaller employers, right? The main reason for taking an employment relationship out of the at-will realm is because the employee is key to the success of the business, and you can't take the chance of that employee leaving suddenly and with little or no notice. All right. So you decide that you're going to lock that employee up by giving them an employment contract for a term or with a just cause provision, which binds the employee to you, at least to some extent. Before we get off this at will consideration, let me just point out that if you're going to offer an employee a contract, in other words, a contract that has a term or a just cause provision, it should be in writing. Okay. And that contract should also have it should have language, which is what we call an integration clause, which says that prior discussions aren't applicable, don't apply, they have no force of contract. This sort of wraps everything up into this agreement. This is what we agreed to, and nothing that precedes it matters. So you want to make sure that you have sort of an integration clause. You can have an agreement with an employee, a written agreement that is not an employment contract, that does not bind you to that employee for a period of time or give that employee a just cause provision. If you do have such an agreement, and David's going to talk about those agreements, please make sure that you include an at-will disclaimer. Please make sure the agreement says the employment relationship is at will. Okay, that way there's no question. Again, the law presumes it, but why take the chance? Why not just put the employment relationship is at will in your contract? David, if we go to the next slide. So now that you've hired the employee, you have to figure out how to pay the employee, right? There are two terms that you may have heard: exempt or not exempt. These are terms that arise under wage and hour law, and they refer to whether or not an employee is entitled to overtime and a minimum wage. Non-exempt employees must be paid a minimum wage, and they must be paid overtime at time and a half for hours worked in excess of 40 in a week. Please note that the federal minimum wage is $7.25 an hour, but also note that state law may be higher, okay? And this gives me an opportunity to raise one point. I'm talking today largely about federal laws, okay? State laws may also impose burdens on employees, as may local laws. And the minimum wage is a perfect example, because the federal wage is $7.25, but if the state wage is over $15, as it is, for example, in California, I think it's almost $15 now, at least, you have to pay the $15 if you're a California employer, if your employee is situated in California. You can't rely on the federal wage as a basis for paying a lower minimum wage. So always be sensitive to the fact that in the employment law arena, you're going to have to at times apply the law that is most beneficial to the employees. It could be the federal law, it could be the state law, it could be a local law. So that's non-exempt employees. Exempt employees need not be paid a minimum wage or overtime. So, hey, that sounds great. We should treat our exempt employees we should treat our employees as exempt, so we don't need to pay them overtime. Dave, if you could flip to the next slide. But if you have exempt employees, while they need not be paid overtime, they must be paid a salary, okay? And I have that word in quotes because it's a term of art. And that salary has to be at least $684 a week, okay? A salary is a weekly payment that does not vary based upon quality or quantity of work. So if someone works 5 hours, they get paid the same salary that they would work if they worked 80 hours in a week. All right, that's the principle of a salary. There are limited deductions allowed. I could spend the next hour talking about deductions. I won't. But the bottom line is that the idea of a salary is that it really is not subject to reduction or deduction. Okay. One exception to this salary requirement, that an individual be paid a salary of at least $684 per week in order to be exempt, is if the employee is at least a 20% owner of the business. If the employee is at least a 20% owner of the business, the salary rules don't apply. All right. So if you hire someone and you want to make them exempt and you don't want to pay them a salary and you don't want to pay them $684 a week, then make them a 20% owner, and then you don't have to meet that $684 a week salary. All right. Just a reminder that just because an employee is paid a salary does not make them exempt. Okay. They still must meet duties requirements. Again, sort of beyond the scope of this presentation, but they have to perform exempt duties, which typically involve supervision of workers and or work that involves the exercise of independent judgment and discretion. All right. So a few extra considerations. If you hire an employee, you must carry workers' compensation for those employees. Okay. You have to set up an account with the state unemployment compensation agency and withhold from wages for UC tax. And you have to withhold federal and other state taxes, and in some instances, local taxes. And if you're fairly large, 50 or more employees, you must typically provide health benefits under the Affordable Care Act. So
No, I'm just going to interrupt here just for a minute.
Yep.
Because although you're going to get into the independent contractors
Yep.
in there, this is why we recommend for all of our startups that do not hire people right away. Engage them as contractors. Therefore, you don't have to withhold taxes. A lot of the stuff, you don't have to set up payroll and all this too. So, but when you get around to hiring, this is the stuff you need to know. But
right. So
right out of the box, don't
right.
hire.
So you anticipated the next slide. So we go to the next slide, David. Not all workers need to be employees,
Yeah.
right? Not all workers need to be covered by the employment laws. There are other classifications of workers, and those include things like, as Kit mentioned, independent contractors. They include interns, trainees, volunteers, and apprentices. Okay, we're going to talk about those. So let's go to the next slide. So as Kit alluded to, employee or not, why does it matter? Well, it matters because many laws that apply to employees, but not to other types of workers. So an employee gets a W-2, right? But an independent contractor gets a 1099. An employee has to be paid minimum wage overtime or get that minimum salary. Independent contractor, there's no minimum pay requirement. Employees typically get benefits if they're entitled to them. Independent contractors shouldn't get benefits. Employment discrimination laws don't apply to independent contractors, although do be careful in Pennsylvania, because the law does provide for some coverage under employment discrimination laws for independent contractors. Labor laws, as a union can only organize employees, okay? So if you have independent contractors, you can't be unionized. And then workers' comp, unemployment comp, typically there is no workers' comp requirement for independent contractors, as well as no unemployment comp requirement for independent contractors. So there's a real advantage to having workers classified as not employees. Keep in mind that the treatment of workers may change over time. So just because you classify someone as X to begin with, they may become Y later on. Just be aware of that. That can happen. It does happen. You need to be sensitive to it. Next slide.
I did this one.
Yep. So yeah, go back to that one. And this is just, I mean, we talk about employees. This is one statute and one definition of an employee. It's the Fair Labor Standards Act. It's the wage and hour statute. An employee is any individual employed by an employer. An employer is any individual or any person that employs an employee. Employee, and to employ means to suffer or permit to work. It's an incredibly circular definition, but it gives you an idea that the law is geared towards finding employee status. It doesn't favor independent contractor status. So if we go to the next slide. So being an independent contractor is to some extent the holy grail, right? Because there's a lack of regulation. but again, it is also strictly scrutinized. Independent contractor arrangements must be reduced to writing. Okay. We talked about employment relationships and how it's a good idea to reduce it to writing, especially if you take the employment relationship out of the at-will realm, right? With an independent contractor arrangement, it is 99.9% likely that you're going to want a written agreement to capture the fact that this person is an independent contractor. There are a variety of tests for determining independent contractor status. David, if we go to the next slide. But they can be distilled down to roughly 12 factors according to this court, which I happen to like this opinion because it basically says, listen, there's a lot of considerations, a lot of tests, but these are the tests, these are the factors that you look at. I'm just going to sort of walk through a few of these. Skill required. If it's highly skilled, it's probably an independent contractor. If you supply your own tools, you're probably an independent contractor. If the location of the work is outside the regular workplace, it's probably an independent contractor. If the relationship is finite as opposed to infinite, it's probably an independent contractor. And if the hiring party can assign additional contracts, it's probably not an independent contractor. If the hired party's discretion over when and how long to work exists, in other words, that they can decide, in other words, the person can decide how long they're going to work and when they're going to work, they're probably an independent contractor. If the person is not paid via salary or hourly, it's probably an independent contractor. Is the work part of the regular business of the hiring party? That tends to mitigate towards a finding of employees. So in other words, if I am an IT company and I hire IT people, those people are probably going to be employees. On the other hand, if I'm an IT person and I hire a janitor, that person may not be an employee because it's not an IT employee. So anyway, you get the idea, right? We go to the next slide, please. Some of you may have heard of the ABC test. This is California's independent contractor test. It has been buffeted by public opinion, by employer or voter referendums, and by changes in legislation. But the ABC test basically takes a very close look at A, right to control. That's the A part, okay, of the test. The B part is whether the worker performs work that is outside the usual course of the hiring entity's business. So in other words, if I, again, run an IT company and I hire a plumber, that's outside the normal course of my business, and therefore the person is more likely an independent contractor. On the other hand, if I hire a person who is a software developer, that may not be, okay, someone who is outside the course of my business. And the last part of the ABC test is essentially, is the person independently engaged in this particular activity? My last few audits with the IRS, this is a factor that the IRS is focused on. Are they incorporated, right? Do they have their own separate business? And if they don't, the IRS almost starts, it seems to me anyway, with the presumption that these folks are not independent contractors. So if we want to go to the next slide.
Mike, go back to that.
Yep.
That first one is a little confusing because if I'm hiring somebody as a contractor, as a 1099.
Yep.
And I am specifically engaging them to write, I will make it easy, create my website.
Yep.
I mean, I'm not telling them how to do it.
Correct. If you're not telling them how to do it, you can certainly tell them what to do. You can tell them a deadline. You can tell them what you're looking for. But if you're there peering over their shoulder, right, and essentially saying, okay, this is how it needs to be done. This is how it needs to work. We need this particular interface in the website, and this is how it has to look. Then that looks more and more like an employer-employee relationship. If you say, listen, this is what I'm looking for, go at it, and then you review it and say, okay, well, here's what I like and here's what I don't like. Can we fix this? Can we fix that? And you send it back to them. That looks more like an independent contractor relationship. Does that make sense, Kit?
Yeah, so all three conditions have to be satisfied?
Yes, under California's ABC test. Let me point out, the ABC test is a very pro-employee or pro-finding the person is an employee test, okay? It's somewhat controversial. I bring it up only because it gets a lot of airplay. People talk about ABC test. This is the extreme, right? This is probably the test that is most likely to find employee status as opposed to independent contractor status.
Okay, so so the second one.
Yep.
I'm hiring this contractor because instead of hiring as an employee, because I'm not ready yet. And what I'm hiring to do is to help build out, the software that's going to run this business. So it's not outside the usual course of hiring. So who's going to come after me?
Yep. Under the ABC test, that's problematic.
Well, we're not in California.
If you're not in California, that's a good place to be right now. Keep in mind that under the ABC test, there are now something like 109 professions exempted from the ABC test.
Got it.
So I think they've realized that this test goes a little bit too far.
Okay.
So keep that in mind. All right. But anyway, I just wanted you to see the ABC test to say what it looks like. One of the solutions that you might reach is you say, hey, listen, maybe I'm going to hire someone from a staffing agency or from a PEO. That way I won't be the employer. Well, contractually, the way arrangement with the staffing agency or PEO works is they will be the employer, right? And the agreement will say they're the employer. I just want people to be aware that that does not mean that you might not be a joint employer. Okay, this is an area that is of significant interest to a lot of people right now. There is a lot of litigation going on about joint employment status, a lot of regulatory initiatives. The NLRB just recently published new regulations as to who is or what is a joint employment relationship, that reverses a Trump board decision, that reversed an Obama board decision. So you get the idea that it's a little bit of a political hot potato, but just be aware that just because you find another person to employ your workers does not necessarily mean you yourself might not have the same liabilities that that staffing agency or PEO has. David, next slide. Another category is the unpaid intern or the trainee. Okay. If you had listened to this presentation 4 or 5 years ago, I would have had a 6-factor test up. It's entirely different than this test. This test is called the primary beneficiary test. It is much more inclined to find that an intern or a trainee is not an employee and therefore is not entitled to some of the benefits of employees. The basic conceit of the test is it asks, who is the primary beneficiary? Does it primary benefit the company, or is it primarily benefit the worker? And you take a look at these various different criteria, and it's a no single factor is determinative. It's a melting pot. You sort of mix them all together and you come up with an answer. But under this test, it is a test that is more favorable to finding that a person is an intern as opposed to an employee. If we go to the next slide.
This has changed.
Yes, it's changed in the last couple of years.
Yeah.
This is a Trump administration test that again favors the finding of intern status as opposed to employee status. I do want to add a couple things. You can pay interns if you really want to. Okay. There's nothing wrong with doing so. In fact, to some extent, it's good practice. If you do pay them, though, you will likely need to withhold and deduct payroll taxes. Interns are likely not entitled to UC benefits, but if they are paid, then that may change. One way of not paying UC benefits is if you hire them for a specific project or a specific duration, and make that very clear. The employee or the intern knows what they're getting into. They know it's only for the summer, and therefore you should not fall under the UC law. Workers' comp, interns can typically not covered by workers' comp, okay, especially if they're unpaid. But I do want to mention that they could be. It's sort of a dicey area of the law. My advice is always to contact your comp carrier and determine whether or not you think they need to be covered. But if the person works sporadically or occasionally, and I think you can define summer interns, for example, as working sporadically or occasionally, then you do not need to cover them with workers' comp. Keep in mind too that this is again, this is a little bit of a political hot potato, and as administrations change, we could see a change in the test. Right now, the test we're working with is a Trump era test. This does not seem to be a high priority item for the Biden administration, but I don't know, the new Department of Labor secretary, if and when she is nominated, may have a different idea on this. So if we go to the next slide, I want to briefly mention volunteers, and I'm going to very briefly mention volunteers. Great, you know, we can get people to volunteer. If you are a for-profit company, as a general rule, you cannot use volunteers. You have to pay the people performing services for you. Volunteer is a great concept if you are a not-for-profit. It is a great concept if you are a public agency. But if you are a for-profit company, you should dispense with the idea that you can use volunteers. David, next slide. Why don't we go to the next slide? For-profit volunteers, there is some availability to use for-profit volunteers for for-profit companies, right? But it's really limited. The example I use is if you want to run a 5K for autism, okay? You can run your 5K for autism. You can ask your workers to volunteer in terms of organizing the race. It has to be voluntary, but if they do that type of work, volunteering at the race, it's not compensable. In other words, it has to be outside their normal work. It has to be voluntary. It has to be outside their normal work schedule. And it has to be for a charitable or civic activity. That's it. Okay. Otherwise, you can't use volunteers. So sort of put that off to the side. Understand that volunteers are not a viable option for for-profit entities. And then last but not least, there are roughly 950 occupations that are recognized as apprenticeable. So you may be able to hire apprentices. Typically, apprentices are employees, but they provide some option for unpaid work or for sub-minimum paid work. Okay, there's also potential sources of funding. Keep in mind that, again, using my example of the IT company, chances are that is not a company that would probably have apprenticeable options. On the other hand, if you need welders, an apprentice program is a great place to look if you want to sort of employ someone that is a slightly different category than an employee. So that is what I want to cover today. I want to cover employees and then the alternative to employees, the contingent workforce. So as an employer or as a company, you have options. You can use employees. That's the safest option, but it's also in many respects the most expensive option. You can look towards a contingent workforce as a source for your labor. Keep in mind, again, that's more risky. It has the benefit of being less regulated, but if you get it wrong, there are significant penalties attached to that particular use of a contingent worker. So if you have any questions, feel free to raise them now, or we'll wait till the end, but thanks for your time.
So Mike, let me ask you a question. And my sense is that there's more pressure over the last few years, broadly defined, on employee versus independent contractors, more pressure on that issue. You see lots of litigation or people on that issue, people trying to be recharacterized as government trying to recharacterize people as employees as opposed to independent contractors. Is
Yes.
that perception right?
Yes, although I have a caveat to that. Pre-pandemic, yes, there were significant efforts, wage theft efforts. People consider it to be wage theft. And so state governments, federal government were focusing very clearly on the independent contractor relationship. The pandemic situation, I think, put the brakes on that to some extent. And I think as we come out of the pandemic and as work returns to normal or whatever passes for normal these days, I think we'll be right back to where we were, which you'll see a greater emphasis on tracking these things down. And again, I talked about how the presumption in Pennsylvania is that someone is an at-will employee. Well, a similar presumption in both federal and state law is that the person is an employee.
And part of that can be triggered by somebody who was characterized as an independent contractor looking in 2020 hindsight and deciding that they'd like to have their role recharacterized as an employee to attain those.
Absolutely. Yep, employees have the option at that point of filing, for example, they could file a complaint with Department of Labor. They could involve the IRS. They could file a complaint with the National Labor Relations Board. They could file some sort of charge with the EEOC alleging discrimination and arguing their employee, or they could simply file a lawsuit under a statute like ERISA, or they could make a complaint to the Workers' Compensation Appeals Board, or they could file a claim for unemployment compensation and argue their employee. There are a million different ways to get in front of someone who will make that decision. And so again, you need to be really sensitive to the idea that you may think that the independent contractor relationship exists, but ultimately your opinion is probably less important than someone else's.
And I will tell you that in my world of selling companies, when you get to that role, buyers are being particularly attuned to this issue, and has created a due diligence item that has really taken on a life of its own, where they start looking and they really delve into a mere representation that says, I mean, you will have to represent to the buyer that you properly characterized your employees. That's a given, and you'll have to indemnify them for if you are wrong. That's a given. But they'll go beyond that, and they're actually dig into what did they do, what kind of controls were they, and they'll do some due diligence into this. So this is an area that I'm highlighting because, and to your point, Kit, our tendency is to make people independent contractors for ease and otherwise, and cost savings up front, which is perfectly legitimate. But I think we need to be careful to make sure there's reality to that characterization in a way that will hold up on closer scrutiny later. That's my statement.
And as the relationship matures, be willing to pivot as well. Okay.
Correct.
If it's a 2 or 3 person operation and you have everybody sort of working on an independent contractor basis, I get that. I mean, probably not going to be a target for anybody. But as the company matures and the relationship with those workers matures, you may need to pivot into a different relationship.
Right. Okay, before we move into my portion, any other questions by folks for Mike? And you can always ask later, but it's a good time to pause. All right, hearing none, but feel free to interrupt me. So Mike sort of already alluded to this, but when you hire employees or independent contractors, you can have a signed piece of paper, or you can have an oral agreement. And I am a firm believer in having written agreements for startup companies, and they can be letter agreements, they can be offer letters, they can be formal employment agreements, they can be formal consulting agreements, but some piece of paper. And in part, it's because startups can't afford misunderstandings. We can't afford litigation. If somebody alleges later that they are entitled to 20% of the stock or options for 20% of the stock, that's a problem. And I've had it happen where employees say, well, I was promised this, you say this, all it takes is a letter from them to say I was entitled to 20% of the stock, they promised it. And now I have an issue that I have to deal with, and I got to make it go away, because I'm going to have trouble getting somebody to invest in the company. I'm going to have trouble somebody buying the company if equity is not unsure, or that there's some claim that somebody's entitled to some compensation that was not paid. So the point is that I kind of like having things in writing. I think it adds clarity, and it minimizes the issues later. So that's sort of my and you'll see we're going to talk a little bit about some of the terms and the covenants, and I want enforceable covenants such as non-competes and all the other things that we're going to talk about. I'm going to add just a point about reading these contracts carefully, these employment contracts or consulting agreements or otherwise, or NDAs or these other things we're doing with employees. They look like boilerplate, they're not. And so it's essential that you, as the company, really understand these things and understand the implications. Where there's a dispute, where's it going to dispute, all the kinds of things that we're going to talk about. So, at least walk through it at least once and make sure you understand it thoroughly. And some of the key terms in the employment or consulting agreement, obviously roles and responsibilities, expectations. It's amazing how many times people say, well, they use a form agreement and this is on the exhibit, and they never really pay much attention to the exhibit. You really need to do it. Be clear about what the compensation is. base, bonus, expenses, what benefits they're going to get. I think Mike already emphasized the at-will, so I won't talk about that much. Severance, I encourage people not to overdo the severance, because that's, if you're firing somebody, you don't really want to pay them that much severance and you can't afford it. And that's another thing that people pay attention to later, because they see this huge amount of severance. And once you have it in there, it's really hard to take it away. So for example, if you decide that you're going to give somebody a year's severance if you terminate them, thinking you'll never let them go, and then you try to get funding, and an investor looks at this and says, you're giving them what? I want that down to 6 months and not a year. That's really hard to renegotiate with somebody. So, I'm not a believer in huge severance. And compensation, I just want to spend 1 moment on commissions, because this is an area that I see probably performance-based compensation or commissions where I see the most misunderstanding. Those are really complicated. So if you say, for example, you're going to pay a commission to somebody based upon sales or otherwise, think really hard about what that means. Is it as an example, if you're in a software business, are they getting it on the licensing fee? Are they getting it on the consulting fee? Are they getting the implementation? What's it based upon, and for how long? Do they get, if the contract is paid later after the employment, do they get the commission on that? Do they not get it? Do they get it? How long is the tail on it? So that's important to think about really hard, and I see a lot of that along the way. We're going to talk about all 4 of these: invention assignment, confidentiality, non-compete, and non-solicit. But the part I want to emphasize before we get into this is that, the clients we have in this space, part of the value of the company is the technology and the business, but a huge amount of value is the employees. And so we need to do to protect the company and keep the employees happy and retained, and frankly lock them up. Because if they walk out, they're walking out away with value. So what I want to make sure is that we own what they create. We're going to talk about. They keep the information confidential. They can't compete. They can't hire the employees. Our employees, when they leave, they can't hire our customers. We want to make sure these things, so we can protect the intellectual property or the assets of the company when they leave. And you'll see on this slide, I have the devil and the angel, and you can decide which one's on Homer's shoulders. One is the potential acquirer, one's the investor, but they want to make sure that there's value, you really retain the value for the company. Let me spend a few more moments on those issues. So number one is that on intellectual property, it's essential that what employees or independent contractors create while performing for the company is owned by the company. Another area of huge due diligence, most recently in transactions, I'm seeing it heavier and heavier on ensuring that there's no leakage, that what the employee creates is owned by the company. That means, in the second part, I'll come back to the first part, but the second part is making sure that there is a current sentence in each of those agreements that says that the consultant or employee hereby assigns to the company, and it's hereby. Right now, it has to be a current assignment of the intellectual property created to the company, assignment to the company. The courts have held that a future assignment is not effective. It has to be a current assignment. So they hereby assign it. And do you want the prospective obligation is an obligation later to execute all documents necessary to effect that. So for example, if I need them to sign a patent assignment to the company, they'll do that. Really important. Just there is a work for hire concept, but I don't spend a lot of time on it because I don't want to rely on it. It only applies to employees. It doesn't apply to independent contractors. So as an example, if I hire an independent contractor for Kit's example, to develop a website as an independent contractor, and I don't have any invention assignment, even though I pay them, I don't own it. I may have a license to it, but they own what they create unless I have an invention assignment. I think I've harped on this long enough, but it's really important. I also want to make sure that they're not going to bring some third-party confidential information into the mix. So I would really hate if Mike's going to write some software. Well, I hate if Mike wrote software anyway. But if we were to engage him to write software for my company, and he were to bring it into the IP from his former employer, that's a problem. And so I want a representation from him. He's not going to do it, and I want a license if it does. The invention thing is you need to be careful about what is an invention. So is it something that somebody creates while they're only on site? That's kind of dopey in today's world because people are doing things remote. So it can't be just while they're on site. Is it only while they're on business hours? I don't know what that means. There's all kinds of business hours. Does it mean what they create while they're in the shower, while they're thinking about this? Well, maybe. So what's the breadth of the invention? And you know, I take a pretty broad view that anything they create related while they're employed by us, related to the business of the company, is owned by the company, because it's too hard to figure out what to carve that out.
So
So that's
yeah, I'm just gonna, when you say related to the company, because we have seen sometimes that some of our startups will begin to work with somebody who's employed by somebody like Microsoft or Google.
Yep. Yep.
And so the idea, the fact is, if they get to a certain point, they'll leave Google or Microsoft and join you.
Yep.
But I've just told all my, the startups I work with, have that person go back and look at their employment contract about what is covered and what is not. Because I know Microsoft, we found, is the one case in particular, they don't really care if you moonlight, as long as you're not doing something that competes with anything that Microsoft is doing. But Intel, in their contract, 24/7, they don't want you working on or for anybody else or anything else while you're an employee.
Absolutely. Absolutely. And it's essential to, it's not just your employment agreement. You want them to look at, you want them to look at everything, including the policies, the company policies, because it's hidden in the, sometimes you sign an agreement that says, I will abide by all the policies of the company, and there's an IP policy, and that policy has the invention assignment inside of it. So it's and it's also sometimes in the NDA. So I just go a little broader and ask them to look at every piece of paper they've ever signed with them, because it may be characterized as something different, and look at all the company policies. And then you can find, but the question is exactly right. And whenever I hear somebody come tell me that they are, one of the founders is working somewhere else at the same time, my antenna go up and I say, okay, well, let's look at the IP. And 99% of the time it's an issue. Because frankly, they're generally being hired because of an expertise, which they're generally doing, in their day job. So it's an issue. Thank you for emphasizing that. Yep. Next is confidentiality, and it's just so important that employees keep the confidential information of the company confidential. Sounds tautological. And it's interesting. Confidentiality really agreement only has two real operative provisions. One is, I will keep the confidential information confidential, and two is, I won't use it for any other purpose. They're both really important. There are exceptions. The exceptions are things like that which you create, which are public domain, not through your own fault, and things like that. But it would not be funny for an employee to leave and be getting or using your confidential information for other purposes. So it's really important. And that doesn't just go for the company's confidential information. It should include customers' confidential information as well. And you want to be, or customers or their patients or whatever it is.
So David, so this is just, you hire somebody, they sign up, they sign all these types of things. And I think we even had a local case involving our self-driving cars. And let's just say the employee violates this. I'm a startup, so I can go after the employee, or, let's just say big company then comes and sues my little company, or is it the employee that's liable?
Well, if the employee discloses it, clearly the employee is liable. So start there. What you're really going to try to do, though, is not liable it's as much as trying to get them to cease and desist using it. And so what you're going to try to do is get a court to enjoin the subsequent user of the confidential information from using it. It's the more typical provision. So as an example, we had a company recently who company B hired a bunch of ex-employees of company A, putting aside the non-compete issue, but hired a bunch of the employees of company A, and company A was very concerned that company B was going to use the confidential information of company A in connection with its business. And so, in addition to other things, we sued to enjoin them from both using that confidential information and from basically hiring those employees, because they would inevitably disclose that. But so we both sued the employees and the company B to cause them not to use that confidential information,
Even though they hadn't done it yet, or you weren't aware that they were.
Well, it was pretty inevitable that they would.
They would, okay.
Yep.
Did you win?
We settled.
Oh, okay.
We settled favorably. But that's subject to the NDA, so I can't say that. Cool. But anyway.
Okay.
Cool. Mike's shaking his head. I'm not sure which way, but he's shaking his head. All right. Non-compete. So non-compete, again, these are non-competes are fairly controversial, and I'll get to the latest on enforceability in a moment. But as a general matter, they're enforceable. It's very state-driven at the moment, and so some states they're enforceable. Some states, for in California, they're not. But in Pennsylvania, they are subject to some caveats, right? They have to get something for it. The employee can't just walk in one day, say, by the way, I want you to sign this non-compete. There has to be something in exchange for it. It has to be a reasonable length of time. It has to have a reasonably related to their business, the business, the things that you're protecting, so the business, and reasonable geographically. So it all has to be a reasonable non-compete. So for example, if you try to hold up an employee for 3 years after they leave employment, that's never going to hold up. A year, perhaps. So reasonable scope, reasonable amount of time. It has to have consideration in exchange for it. In Pennsylvania, at least, hiring somebody is sufficient consideration. So if you hire somebody and you get to sign a non-compete at the time you hire them, that's sufficient consideration. If you go to them 6 months later and say, oh, by the way, I meant to get you a non-compete, that's not adequate consideration. So it's important to get it out front, up front. There is, it is interesting to me that was something that I've always taken sort of granted, that non-competes are enforceable or have gotten heightened scrutiny of recent. And the FTC only proposed a rule relatively recently, January 5th, that would basically make non-compete provisions unfair methods of competition and not enforceable, superseding all state laws. This has gotten a lot of press. It would apply to employees and independent contractors. Interestingly, the law says that the existing non-competes would need to be rescinded. So employers would have to go to them and say that you are not subject to a non-compete, affirmatively so. If you're selling a business, it doesn't apply to that. This is only for the employment relationship. This is during the comment period. This is not enforceable. This is not the case today. So we're still putting non-competes into place. Hopefully, this will not end up being a rule that's promulgated, but that's out there. That's something, and it gives you sort of a sense of sort of the mood for enforceability. So I mean, I'm not taking the actions with this. My clients, we're still signing non-competes, but we're putting a little more emphasis on the other protections, the confidentiality, the non-solicit. We're going to talk about those kinds of things. We're making these more reasonable, more focused, because I think they're getting a lot more scrutiny. Mike, do you have anything to add or complain about that?
Yeah, the only thing that I add is just that, keep in mind that a non-compete applies both during the term of employment and then post-employment. And typically the controversial part is the post-employment. So I do think that notwithstanding the proposed FTC rule, that there's still a purpose, even if the FTC rule were eventually implemented in one way, shape, or form. I still think there's a purpose to non-competes in terms of the term of employment as opposed to the post-term of employment. You obviously don't want employees moonlighting at jobs that are directly competitive. And I think especially in the gig economy where people are oftentimes working multiple jobs, you sometimes get that.
How will that impact the issue of non-disclosure? I mean, one of the reasons companies have non-competes is so that trade secrets won't be disclosed to competitors. How will, if those proposals are adopted, how will that impact non-disclosure issues?
It's a good question. So theoretically, you would rely on the confidentiality because they're trade secrets, and so you would get folks to. Can you guys? Mine says Zoom quit unexpectedly. Can you still hear me?
I can still hear you. I can still see the screen.
Okay, cool. All right, cool. So arguably, they they protect something different, right?
Yeah. So David's a little bit out. So let me just
Wait a minute,
add.
we lost you. May I see? Do we have David on here? No.
Yeah, so let me just add to what David was saying, which is that I mean, I don't think the prohibition of non-competes will impact NDAs or confidentiality agreements. I think those are still allowed to be enforced. And obviously, as David suggested, those would really be the primary vehicles by which you protect your IP.
So let me, I can bring up the last of the presentation.
Yep.
Wasn't quite prepared for this, so. And my system is slow.
Can you guys hear me?
We can hear you, but the
Good.
presentation disappeared, so.
Yeah, okay, we'll get it back. Don't know why I did that. Sorry, 1 second.
So while you're pulling that up, we do have a question in the chat on the topic of intellectual property. The question is, how much of it is required to be public knowledge, such as in patents or trademarks? And I don't know if you need more clarification on that question, but if you do, Joshua can pop up.
I'll take a shot at that. David may have another view. There is generally a carve out in confidentiality and NDA type provisions for publicly available knowledge. Generally speaking, there's no protection for that. You can certainly try to protect it. Just because it is not a trade secret does not, or for that matter, confidential information under a Uniform Trade Secrets Act, you can still protect it contractually. Just be aware that if the language, or if it is truly out there in the public domain, it will be very hard to enforce that contractual provision, and it almost certainly won't be considered confidential information or trade secrets under a statute.
Cool. So one, sorry, there's lots of connection there for a moment, but on the question regarding the enforceability or the confidentiality, there is a note in the proposed rule that says that you can't do an end run around this through other mechanisms, including the confidentiality agreement. So I think they're going to be, and maybe you said this, Mike, for which I apologize, but they're going to be heavily scrutinized as well to make sure that they're not being used to back end into a non-compete. Legitimate non-competes, I think, will be enforceable. But I think
Legitimate confidentiality arrangements, yeah.
yes, but you can't use the confidentiality provisions to basically do an end run around to basically create a non-compete.
So for example, if you define confidential information so broadly and
Correct.
so widely that
Yes.
effectively the person can't work anywhere,
Correct.
that will
Yes.
be viewed as a non-compete. It's the same with non-solicitation agreements, which you're about to start on, Dave, which is that, again, if the non-solicitation is so broad and so unreasonable, it may not be, it may be considered the equivalent of a non-compete.
Yep. That's interesting. The rule specifically calls out confidentiality agreements.
Yep.
All right. So we've covered non-competes, we covered confidentiality, convention assignment. The last is non-solicit. And again, it should be, but you don't want people leaving and then stealing your employees and your both current and former employees and your customers. And that goes to current customers and prospective customers. Taking your customer list and going after them. And again, we had one recently where the former employee went after the current employees. And so they just don't want them doing it. So you want to be able to have a basis upon which to stop it. Suppliers, et cetera. And you'll talk about a reasonable length of time, et cetera, but that's just essential to have. When doing these things, obviously my favorite remedy is an injunction, which is you've got to get a court to say, stop doing that. Thou shalt not compete. Thou shalt not use confidential information. There is a provision sometimes you say while you're breaching, then it's extended for that. So for example, if you go non-compete and you compete for a year until we finally get the injunction, then it's extended by another year. That's another thing. The third one here, buyback stock, is pretty important, which is to say, if somebody's got employee equity, whether it be options or otherwise, and they hold, and under your plan, they hold on to it after they leave, but your provision says that you get that back. They lose that if they breach a restricted covenant, such as a non-compete, confidentiality, or non-solicit. It has the effect of both. The good news is it creates a incentive not to run afoul of that. And so I find that it's helpful to have that because people are more likely not to breach it because they actually have an economic reason not to. They're going to lose this stuff.
So
similarly on the last,
would they buy back at the current market value or would it be a reduced price?
reduced price,
Okay.
reduced price. Yep. And it's essentially like a termination for cost. But looking backward. And the other is collection of legal fees and costs, which is to say if an employee breaches and I have to sue them, they ought to be on the hook for the legal fees and costs, and they agree that up front. So if I'm successful in getting injunctions, they got to pay it, and that creates additional incentive on their part not to breach. In the fine point, you can talk about whether the forum for litigation with arbitration or courts with respect to at least the employment agreements themselves. You're going to go to a court to enforce get an injunction. But for the rest of it, arbitration versus courts, different people have different views on this. I'll tell you mine, which is I'm not a big fan of arbitration. It has the benefit of being non-public. That's a good thing. It has the benefit of, some people think, relatively less expensive. I don't buy that. But the reason I really don't like it is because there's no appeal. So if an arbitrator, if you don't like what an arbitrator does, there's no appeal from arbitration short of fraud or something extraordinary. And I'm not a big fan of that. So other people are, I'm not a big fan.
So David, is the buyback stock and the collection of legal fees, is that actually in the employment contract? Is it?
Yeah.
Yeah, it is. Okay.
Yep.
Okay.
And governing law, you can pick your law carefully. So that doesn't necessarily govern everything. For example, if you're hiring an employee in California, even though your piece of paper says the governing law is Pennsylvania, Mike, tell me if I'm wrong, but I think I'm still going to be subject to California law if the employee is in California. But be that as it may, it's still better to pick a governing law that's favorable to what you're trying to accomplish. That takes me to employee equity. What somebody has something else on the employment arrangements. And I'm not going to go through this real carefully, but I just want to make a couple points about employee equity. And this is, yeah, again, part of the reason to do this is because, especially in today's environment, it's, employees are part of the value. And so it's important to give them incentive to perform. And this is a helpful way to attract and retain talent. I'll also say that's the only reason to give equity is to attract or retain talent. I have clients who disagree with this, by the way. There are clients of mine who like to give equity to every single employee and feel like they have ownership. And that is certainly a valid perspective. Mine's a little different. You need to understand that I'm cheap. Second, I also think that I only have 100% equity to give out, so I'm kind of miserly with my equity. And third is that if it isn't necessary to attract or retain employment, I'd rather pay them cash. I'd rather give them a fair value for their services, and then and keep the equity for people that really need it and can really drive the value. So there are different kinds of employee equity. I'm going to run through them quickly. I'll go through restricted stock, options, profits, interest, and phantom equity plans. Let me do them real quick for you. But before we get to that, let me just do a couple preliminaries. All of them have it in common. When you give employee equity to employees, whether it be restricted stock, options, or anything, it's essential that you have some vesting. It is not funny at all to hire an employee and give them equity and then walk out 3 months later and have all that equity. Not the good plan. So you want it to vest over time. So if you give somebody 100 shares, maybe you have it vest over 4 years, and so they'll get 25 shares each year that they're employed by the company. So that's point one. So vesting over time. Sometimes you do performance vesting, so based upon their performance or the company's performance. Those are different ways, and you can certainly do that. A little more complicated, but it can be done. Most times people do time vesting, and I have come to the conclusion after too many years that simplicity is our friend, and sometimes just time vesting is a good way to do it. If you're not happy with the employee, they'll leave, you'll quit, they'll leave, you'll fire them, and so performance vesting sometimes isn't as it's a lot of fanciness for not necessary, but that's one way. Clearly, if somebody leaves, they lose their non-vested stock. That's easy. One of the questions is what happens to their vested stock? And I happen to believe that you want to take back vested stock as well. So for example, if somebody should enjoy the benefit of the increased value while they're employed, but they should not enjoy the benefit of the value after they leave. So if the company goes from, if you give somebody 10% of the company, just for example, and the company goes from $1 million to $2 million of value while they're there, then they should get 10% of the $1 million increase in value. I don't think they should get 10% of the $2 million value till it goes public. So we get an opportunity to buy vested stock at the then fair market value, payable over time, so it doesn't break the bank. So that's something to consider. That is a provision that is much negotiated between the lawyers and the clients really like having it at the end of the day. So I'd encourage you to think about that. Okay, one of the forms, we're going to do these quickly, is just giving people stock. So when they give them restricted stock or just stock in the company, and it can be limited liability company membership interest, or it could be corporation, but it's basically stock. And basically it says, okay, here you are, you have 10 shares of stock. Congratulations. Oh, that's kind of nice. They have ownership. The downside is that it is taxable. So it's taxable when you get it. So if I just give Mike Pavlick 10% of my company and it's worth $1 million, and I give him 10%, he's got $100,000 of tax upon receipt of that, period, done. It's a little worse than that even. If the stock vests over time, then by the way, let me finish the first one. The good news is that if you do it when people early on, you take the view that the company isn't worth a whole lot. So granting them the stock, it's not worth a whole lot, so you're paying tax on a very, very low amount of money. So granting people restricted stock early on is when you do that.
So
when the value is low.
Yeah. So David, if it's pre having an investor, an industrial investor, So who determines what the value is? Because you give me some stock, but who's deciding what the price of that stock is? Or the
Mhm.
value?
So the company decides what the value is. And typically, if I'm going to give it, I will either based upon the amount, sometimes you do just about the money the amount that's been invested in the company, because that's probably very low.
Okay.
Sometimes you may do a 409A valuation. If you're on Carta, which is the online service, they'll do a valuation for you, a very, very nominal amount. And they'll give you a valuation. So
Okay.
nowadays, most of the companies now keep their records, startups keep their records on Carta, which is an online service. And they have a service that's fairly nominal to do a 409A valuation. That's what I would do.
Got it.
So one more thing, just this kid will kick me if I don't do my 83B lecture, which is that if you get your stock up front, but it vests over time, then each time it vests, you have to pay tax on the value when you receive it when it vests, when it vests. So if I get stock that vests over 4 years, I'm going to have to pay tax on the value of that at year 1, value at year 2, value at 3, and value at year 4. And hopefully, if the world works perfectly, the value is increasing, so I have to pay a lot of tax over time. That's a bad result. The good news is that you can get around that by filing in what's called an 83B election, named because it's Section 83B of the code, which allows you to pay tax on the entire amount on the day of receipt. Now, presumably, as we were alluding to, the value will be very low at that point, so you pay very little tax, and you got to pay it up front. In order to file that 83B election, you have to file it within 30 days after you receive the stock. Did I say 30 days? I said 30 days. 30 days after you receive the stock. There's no mother may I, you can't go beyond that. It's got to be done within those 30 days. And so that is an area that some people don't pay attention to, and it's really important because there's no way around it later.
Okay, so I'm going to make a little plug here. This is one of those little tests I do. When somebody said, oh, I want to work with startups, and I said, well, do you file 83B elections? And when you see the blank stare, because they're a litigation attorney or their family law office in there, this is why you want to work with a startup lawyer that knows this type of stuff. And I actually had an employee who this company he was like 4th employee, and he had a really successful exit, and he was in here in Pittsburgh, and he was working for one of our startups, and he never filed, or his lawyer never filed him, or never told him about the 83B election. He had to actually, I mean, it ruined his life. Yeah, he was planning to live on the proceeds.
Well, that's sad. Yeah, I don't want anybody to ruin their lives. Yeah, but so the idea, I mean, yes, it's good to deal with lawyers who do this. I mean, as I always say, I wouldn't be very good doing doing personal injury, and I suspect that the personal injury lawyers wouldn't be real great at doing this. So there's lots of lawyers around that know this stuff, but you might want to work with one of them. All right, so the benefit to getting the stock is that you have the stock. So when you sell it, assuming you hold it for more than a year, you get favorable capital gains treatment, which is much better than ordinary income. So that's good. So the good news is that you can, if you do this early, you can get capital gain. They own the stock. So it's a favorable tax treatment. Another alternative, is to give people options, which is quite common, right? People get options all the time. And most of the time what startups end up being non-qualified stock options. And all that means is they don't qualify for special tax treatment, which I'll discuss in 1 minute, for 1 minute. But non-qualified stock options, the good news is when you get an option, then all an option is a right to buy a share of stock at a value. So you establish the purchase price, exercise price at the current value, and you have a right to buy that share at that value. As straightforward as that. When somebody grants you an option, it's not taxable. That's a good thing. Unlike the restricted stock, not taxable. You pay tax when you exercise the option. That's really important. So so you pay tax at the ordinary income rate when you exercise between the then fair market value and the exercise price. That's important because if you wait too long to exercise that option, there's no cash coming your way. So you have to have the cash to pay the tax. So typically you wouldn't exercise the option unless either somebody helps you pay for it or you or there's a liquidity event, basically the sale of the company, because it's really hard to exercise that option and pay tax. I mean, it can be done if you do it relatively, but if you get too far along the line, it becomes expensive. But the good news is that once you exercise it, that assuming you pay, you hold on to it for a year after that, you pay capital gain on the difference between the then sale price and the value at the time you had exercised. If you have an option, you don't own stocks, you don't participate in dividends, and you don't vote, but you have that option. So basically, it's a right to have the upside in the stock from the fair value when you got it, at a potentially less tax advantageous manner than the restricted stock. The elusive qualified stock options, qualified options, as I like to call them, this is the best of all worlds, which is that you get the option, you don't pay tax on it when you get the option, you don't pay tax when you exercise, although exception alternative gain, and when you sell the stock, it's a capital gain. Yay, the best of all worlds. But there's a lot of restrictions, a lot of requirements, and some of it is that it only applies to C corps, number one. So if you're LLC, this doesn't count. The option has to be issued fair market value. That's okay. You got to hold the stock for at least 1 year after you exercise, and that's where the rub is, because most of the time you will end up exercising the option at a time that you're in connection with the sale. So it'll be so you won't get this value, so you end up paying ordinary income rates anyways. But that's okay. Others are it can only be given to employees, can't be transferable, has to be exercised within 90 days after termination of employment. And the last one's one that people forget about, I want to highlight, which is that if you're above a 10% shareholder, there's special rules. The fair market, the exercise price has to be at least 110% of the fair market value, and unlike the regular incentive stock option, the exercise period can only be 5 years rather than 10 years. The point is that most of the time you're going to end up giving people restricted stock, regular options, which is okay. You're giving them upside or restricted stock. ISOs, not so much in this
So
world.
David, I'm employed. Yep. My company has a great exit, and so I have stock that I have qualified options, and then the company terminates me must be exercised within 90 days after termination of employment. So it's only after I've been fired, right, or let go. I have still 90 days to exercise this.
Yeah, well, that's unrelated to the sale. I mean, under the sale, it's all going to be taken care of in connection with the sale. The sale of the company, you're going to exercise during that sale price, and you're going to get the proceeds of the sale.
Okay, all right.
So, yeah,
okay.
This is only that's pre-sale.
Okay.
Profits interest is another one, LLCs. This is, I'm going to spend 1 second on this because I'm almost out of time, but in a limited liability company, this is the, you get basically an ownership interest in the LLC in an amount, and you get special profits interest, which is the right to own a piece of the company, and you get the benefit of the value from the day you come in to the day you leave. So the company's worth $1 million when you come in, it's worth $10 million when you leave. You get that percentage, or the number of units equivalent to the increase from the time you come in to the time you leave, the $1 to the $10 million. But you're a partner and all that stuff. So that's kind of confusing. It's only on LLCs, and they should only be used for executives because it's very confusing. So I'm going to skip the examples because we don't have time to do that. So the bottom line is restricted stock is great if it's a low value. Profits can be attractive if they're in a limited liability company, so consider that. Non-qualified options are a great way to do it, and don't forget about 83B elections. And the only thing I'm going to talk about the amount of the options is the only person attracted to maintain talent. Don't give it to everybody, as I said. And if some people often ask me how much in options, and a pretty good rule of thumb is 10 to 15% of the company. And that is everything I have, with a minute to spare.
Very nicely done. So for everybody, that this presentation is both on the Pitt Big Idea Center website. It's also going to be on the Short Center under Workshop Archives. So if you want to go back and look at David's example that we didn't have time to cover, that we can do that. So for those who are still with us here, David and Mike, thank you very much. And let me just, we forgot to ask your permission to record this. Do you have anybody here who has spoken have any issues with having this available publicly?
I'm certainly fine with it.
Okay, well, good. That's a lawyer speaking. So Mike, you okay?
Yeah.
Okay. All right, we're good. So thank you. That was
Thanks, Dave.
well done, very thorough, and I feel educated and updated. There's some new
Oh,
changes.
good. Cool.
Yeah, I think the biggest
Thanks.
takeaway for me is how much things have changed and continue to change, and therefore
Yeah.
constantly having these sessions is really important.
Yeah. Particularly on interns. That was very helpful. So
Good.
Thank
Thanks,
you.
Dave. See ya.
All right, see you,
Good night,
everybody.
everybody.